Hey y'all, what's poppin'? Attorney LaConnie Murray with the Legal Tea. What is up? We had a different format for y'all today. We have been spilling this tea over here on this podcast for a few months now. So what we want to do is give you an update on some of the stories that we have previously talked about. And we got 3 that we're going to talk about today. We're going to talk about Nickelodeon, we're going to talk about Cardi B, and we're going to talk about the Soulja Boy Fornite case. All right? So listen. A few months ago, maybe like early in the summer, we talked about Nickelodeon. So first of all, who remembers Nickelodeon's Double Dare? I do. Being slimed at the end. Yeah, I remember that. So we talked about how they let their trademark go. And as a result, when they got ready to bring the show back, this guy named Charles Armstrong beat them to the punch and filed a trademark registration for Double Dare and Double Dare Live. So here's the update to that situation. And since we last talked, what has happened is Nickelodeon, through their company Viacom, is who owns them. They filed opposition to Armstrong's trademark. So what that means is, in the process, what happens is you file your trademark application. It sits in their database for 3 months, and then it goes to an examining attorney for them to review. After it's reviewed, if there are no conflicts, if they don't see a conflict, then they will publish it for third parties to object to the registration of that mark. And they have 30 days to object. So the reviewing attorney did not see any conflict. He published it to the public for 30 days, and that's when Viacom filed their objection to the registration of that mark. But previously, before they filed the objection, while it was still in that reviewing phase, they filed a civil lawsuit in the state of New York asking for a declaratory judgment, asking the court, hey, I want you to find that we own this trademark, okay, that we are the owners of a trademark. And so with the declaratory judgment, what that is just asking the court to find, like, where do the parties stand legally? We want you to make a decision. We're not asking for any money. We're not asking for any damages. We're not asking you to tell the other party to do something. We just want to know where the parties stand. And so in this case, Viacom wants to know, they want the court to declare that they are the owners of the trademark. They say they have a common law interest in that trademark. We will see how this plays out. We'll continue to watch it. As of right now, what they did, because they had that civil lawsuit, they filed to suspend the action that's at the USPTO. So that's suspended, and all the applications are suspended pending the outcome of this civil case. So that's what's going on with Nickelodeon and Double Dare. We'll see. And also, they've also filed, Viacom for Nickelodeon has filed 2 trademarks of their own, one for Nickelodeon Double Dare and one for Nickelodeon Double Dare Live. Both their applications are suspended, waiting the outcome of the civil action. All right, so that's the update on that. The next update is for Cardi B. She actually launched a line with Fashion Nova maybe last month, and it sold out as soon as they did. And remember, we talked about a few months ago that Fashion Nova has actually filed like 4 trademark applications for Cardi B, and that they all received offense actions. Because to file a trademark for a living person, you need that person's written consent, and at the time they didn't have it. Well, since we were last here, Cardi B actually did file consent and give permission for them to use her likeness for their trademarks. Now, that's not something I would have done. I personally would have filed for my own trademarks and licensed my name out to them to use so that I can have control over how it's used. But I don't know what type of agreement they have, but whatever the case is, she did file and give them permission to file a trademark under her name. Now, like I said, they have 4 pending trademark applications. So they responded to the office action, and now their applications are suspended as well. They're waiting for the outcome for Cardi B. She did file her own trademark, but it's in a different class. The Fashion Nova trademarks are in for clothing, and Cardi B's is for entertainments, but she did file hers. It's been, she responded to the office action, and we're just waiting for approval for registration. And then there was a third random party that they're waiting on. Somebody named Tiffany Small filed an application using Cardi B's name. An office action was put out on June 5th, and as of today, which is the 10th, She has not responded, so that application will be abandoned. Once those two applications are resolved, then Fashion Nova will be able to move forward with registering their name. I guess it's going to be interesting to see what's going to play out between Cardi B's trademark application and Fashion Nova, since Cardi B's trademark application is actually holding up the progress for Fashion Nova. So we'll see how that works out. Again, keep you updated. Another one that I want to talk about was Soulja Boy. So we talk about Fortnite, and Fortnite really has to do better. A few weeks ago, we talked about how they're basically appropriating Black culture by using these dance moves in their game that's been created and made popular by Black artists, but they're not compensating, they're not paying these artists, and they're not giving them credit. And they're even going so far as to change the name of the dance, like people can't know or tell what the dance is, And we talked about it as it related to Soulja Boy and how he said that Fortnite couldn't use his dance to Superman in the game because he had it copywritten. Well, you can go back to episode 7 and listen to that, and when we talked about whether or not he can copyright a dance move. And the bottom line is that he can't. But in that episode, I talked about how they might have a claim for right of publicity, where basically people have the right to make money off their likeness and stop other people from using and making money off their likeness. Well, since we recorded that a few weeks ago, the rapper 2 Milli, he actually brought a lawsuit against Fortnite, and he states, I'm going to read it. If you have players in the game doing the Milli Rock, I would say that's for promotion. It kind of helps me brand myself. When you use this without permission and you begin to sell it online, that's when it becomes a problem for me. And again, I agree with that. And I really hope that more artists follow suit and sue Fortnite for using their likeness to promote their game. I mean, it's $1 billion company. Come on now, you can do something. You're not giving these people credit for saying that, hey, this is such and such dance move. You didn't change the name of the dance like people don't know. You're not even using their songs as it relates to the dance move, because at least if they use their song, then they would get licensing. They would get money for licensing in that way. Like, they're just trying to avoid compensating and giving people credit for where credit really is due, and that is really not cool. So as we said with the Cardi B and the Double Dare case, we're going to keep you updated. I'm really interested to know how this will play out. I don't think that his copyright claim is really strong, but definitely this use of likeness. People know, the dance is popular. People know when they see the dance who it came from. And so Fortnite has to do better. So our top takeaways from today. First takeaway is maintain your trademark registration, people. Okay, you either maintain it or you're going to risk your application being abandoned, and you could be in the case with Nickelodeon where you got to pay a lot more money because you didn't just keep up with your registration. Okay, the second thing you want to do is file for your trademark as soon as possible to avoid delays, and again, avoid having to pay additional money. Right now, Fashion Nova's trademarks are delayed because they have to wait on 2 other applications that beat them to the punch. So they're waiting for whatever the outcome is for that Tiffany Smalls person and Cardi B for them to be able to move forward. But it's not just this situation. I see it happen all the time where applications are delayed until registration, another mark, whatever is either registered or abandoned. So that can be really frustrating when you're trying to move forward and see if you're actually going to be able to launch your products and services using this brand. So go ahead and get it done sooner rather than later. Even though you do have common law interest in your trademarks, you don't want to wait because it can end up costing you more money and delays, right? The third takeaway from today is be like 2 Milli, right? Recognize that you bring value to others and don't let people benefit from that value you bring, without your permission. 2 Milli said that when Beyonce and J-Lo wanted to use his dance in their performances, they reached out to him, right? And they were able to use it because they got his permission. Make people come to you, right? Don't let them just benefit without you having to say so on them benefited from your likeness, from your goodwill, from the work and energy that you put out there. So that's the third tip. You got to recognize the value, and not just recognize it, you have to demand that people respect the value that you bring. Okay? That's today's episode of The Legal Tea. You know what to do. If you like this episode, share it with your friends. If you found it useful, like it, rate it, subscribe. All right? And we will see you next week.